Hello, and welcome to this presentation on FERPA. You're here because you're an employee of USD 489 Hays, Kansas. FERPA is a very important law, and it's important that you learn about it. FERPA stands for the Family Educational Rights and Privacy Act, and it's been around since 1974. You may have also heard it referred to as the Buckley Amendment. Its primary purpose is to protect the privacy of our students' educational records. It applies to any school that receives federal funding. This may be public, elementary or high schools, private schools, colleges, anyone that receives those federal funds. Our district schools obviously receive free and reduced lunch funds and Title I funds, so we must comply with this law. This law applies to all students under the age of 18 for certain aspects, and also to students 18 and over for other things. There's a pretty good list of information that's protected or considered private by this law. Some of them include social security number, course grades, courses taken, behavioral medical conditions, parental financial information such as the free and reduced lunch program, student parental custody, standardized test scores. Every year we take the Kansas State assessments. Those scores are considered private. High schoolers have to do the ACT or SATs to get into college, and at the elementary level we do the MAP testing. Those scores are all protected by this. And also race, ethnicity, and nationality. So some things to consider: grades. Teachers should keep their tests locked in their desk. Their computer and their grade book should be password protected so that nobody can get unauthorized entry into that. For some behavioral medical conditions, ADHD is a good example. That's something the teacher definitely needs to know to teach that student at their best, but if that information got out, it would probably be something that the student would get made fun of for. So that's another reason why this information needs to be protected. This includes many different forms of the information. If it's a handwritten form, if it's an electronically printed document, or the electronic database itself, all forms of this information must be protected. In order to view this private information, written consent must be gotten. If the student's under 18, consent must be received from the parent. If the student's 18 or over, consent must be gotten from that student. And in this written consent, it must state exactly what information can be released and to exactly whom. And it's important that those consent forms be kept on file. It also means that in our district we have a lot of Hispanic families and also some Chinese families. We must make sure to have translations of these consent forms for the parents to accurately give their consent. There are some situations that don't require written consent. Some of those would be if school staff has a legitimate reason to view the information, if the student is leaving and transferring to another school. The new school is obviously going to need that information. Sometimes schools have to present information for auditing or accrediting purposes. If there's ever an emergency or safety situation, the staff member in charge will need to know that information. And then also legally, for judicial orders, subpoenas, or police officers with the juvenile justice system can view this information without written consent. But for the most part, written consent must be gotten. There is some information that's still private but not considered as private, and that's called directory information. And that includes many things like the student's name, address, phone number, birthday, their attendance, grade level, photo, etc. Awards, achievements, that type of thing. At the beginning of the school year, the parent has the right to opt their student out of this directory information being released, because normally directory information isn't considered private and can be released. So at the beginning of the school year, the parents do have the opportunity to opt their student out of that. And for the most part, we don't have to worry about that because our online enrollment system, which all of the schools use now, has this consent form. And they have the ability to opt out on this online enrollment form. So this situation is already decided before school has started for our schools. It's important that each school and possibly each classroom keep an exclusion list for parents that didn't want the directory information released. So for example, if a second grade teacher wants to release a birthday list to her students, that's legal unless a student has opted to exclude their information from this. So you do have to be careful about that. Always double check your list before releasing any of this information. Parents do play a very active role in their students' lives and with their permanent files. Parents have the right to view their students' records at any time. They have the right to suggest corrections if they think something is inaccurate. The school then has to review the information, and if they still agree with their assessment that it was correct, the parents have a right to a hearing. If the school still decides their interpretation was accurate, the parents do have the right to include a written objection that will stay in that student's permanent file relating to whatever information they felt was inaccurate. So there again, with our non-native English speaking parents, they may need an interpreter present at a hearing of this type. As teachers, there are certain situations where you might have to share some of this private information. The principal is obviously one person you could share this information with, because the principal should already know all the information in the student's private files. You may also share it with teachers that also have that student, the school counselor or school psychologist, or other staff that come into contact with the student on a regular basis, such as paras, recess duty personnel, lunch supervision. However, this is on a need-to-know only basis and does have its benefits. For example, if you're just having constant behavioral problems, it may be worth it to talk to one of the student's other teachers to see if something has worked better for them, or if the student seems depressed or has a sudden change in behavior, it may be worth it to talk to the school counselor or school psychologist to see if they can get to the root of the problem. If you do communicate with other staff about private information, make sure that it is in a private setting. So the teacher's lounge would not be a good place, because there will be people that don't have the student or don't need to know information about the student. The hallway is also probably not a good place, because teachers could have their door open and other students could overhear. So just make sure that the information needs to be shared, and it needs to be private if you decide to share that with one of these people I've just mentioned. A good rule to go by is, when in doubt, keep it to yourself. And if you don't have anything nice to say about a student, don't say it at all. That's something that we teach our students at a young age, so it's something we should probably also follow. FERPA is becoming more and more important, and it's an easy way to get yourself into trouble if you forget to comply with these privacy rules. Well, I hope you've learned something, and always remember,